sixth session of our seminars. And, well, it's weird, I'm speaking English, but since we have a guest here, that's what I'm going to do, at least for the first half of the session. Today we have, again, two speakers and two topics. The first one, we're going to cover resale price maintenance. We have a guest from Switzerland, Professor Canapa. Thank you for coming here. He's going to talk about resale price maintenance, and in resale price maintenance, there's a particular issue where we already faced in Turkey as well, which is the usage of concerted practices in vertical relations. We have observed this in a case in Turkey. You probably recall that in oil and gas distribution, the OPET case. And there was no evidence, almost just economic evidence. And for somehow, Turkish Competition Authority used the concept of concerted practices, not explicitly, but implicitly. And the case was annulled, probably you know it. So this case is quite important from that aspect. It's a case, I think the Federal Court, right?
Supreme Court,
Federal
yes.
Supreme Court has decided. It's a Viagra case, right? It's called Viagra. And he'll talk about this, and we'll discuss similarities between Turkish practice and Swiss practice. I think it's a very controversial case, and I'm not going to talk about it anymore, but there are similarities with the Turkish practice. So that's the first topic. Again, thank you to Mr. Canapa for coming here and presenting this topic. And second guest is, you know him, Muzaffer Eroğlu from Competition Authority. And he's going to talk about non-economic considerations in competition law enforcement. And particularly in that regard, he will talk about gender equality, right? Muzaffer? Yes, gender equality. Yes. That's the topic he's going to cover today at the second session. So we have 40 minutes for each presentations. I'll warn you like 10 minutes before the end of the time. But since you're coming from Switzerland, we have time, apparently. We have a tolerance. We always have a tolerance, so we have a tolerance here as well. And we're going to have a break before 8 for 15 minutes or 20 minutes. Then we're going to start the other session, and hopefully we're going to be on time today and finish everything before 9:50. Okay, so we try to do that. Sure. Okay, thank you again for coming here and waiting for your presentation.
Thank you very much, Jem. Yeah, thank you for your very kind invitation to be here this year at your Competition Law and Practice seminars. It's a real pleasure and a real honor for me to be here with you today, to stand before you tonight, and to have the chance to present you this quite interesting case of, as Professor Jem told, the Federal Supreme Court of Switzerland. I would also like to thank Mr. Dennis Damli, that you also all know, for all the administrative help he provided and made sure that I could make it here tonight before you. It's my first time in Turkey. I think I took the bad weather with me from Switzerland. I'm very sorry about that. But I mean, it's for now I have had a fantastic stay, and yeah, I'm glad to have a chance to be here with you today. So as Professor Jem Sanli told, what I'm going to talk today is about a ruling of the Federal Supreme Court of Switzerland, so the highest judicial authority of the country, that was made in February 2021 on the assessment by competition law of price recommendations when the price recommendation is made through a platform. So it's kind of a special case of price recommendation of resale price maintenance, because the price was made through, this recommendation was made through a platform. And I will already go to the conclusion in a sense. What did the Federal Supreme Court say? It confirmed both the decisions of the Competition Authority of Switzerland, the COMCO, and of the Federal Administrative Court, so the court of first instance on federal level, saying that basically a price recommendation made through a platform could be qualified as a concerted practice that is prohibited by Article 5 of the Swiss Cartel Act, basically the Swiss equivalent of Article 101 of the Treaty on the Functioning of the European Union, or of your Article 4 of the Turkish competition law. And yeah, so such a price recommendation would constitute an agreement affecting competition. So what are we going to discuss today? And it was working, it's not working anymore.
Now working.
No, it's okay. So I will just go more also to give you an idea what Swiss competition law is and yeah, the equivalent of the articles in Turkish competition law. Then we will go through what a price recommendation is, what a concerted practice is, really shortly to set the floor in a sense. And then most of the presentation will be on this case of the Federal Supreme Court of Switzerland, as you can see from the 4th of February 2021, Pfizer Viagra case. You will also hear speak about the Orlist medicament case because it's a medicinal product that is not sold under prescription. And then I will go through some compliance measures that should now be applied by undertakings in order to avoid that the price recommendations that remain legal, but to avoid that price recommendations qualify as illegal concerted practices. And I will conclude. So Swiss competition law in a nutshell. I mean, let's start with the basics. Article 96 of the Federal Constitution of the Swiss Confederation, which says, among other things, that the Confederation shall legislate against the damaging effects in economic or social terms of cartels and other restraints on competition. Based on that, we have the Federal Act on Cartels and Other Restraints of Competition of the 6th of October 1995, which aims to prevent the harmful economic or social effects of cartels and other restraints of competition, and by doing so to promote competition in the interests of a liberal market economy. And then, just as you have in Turkey and as they have also in the European Union, we have the 3 pillars. So restriction, agreements, restriction, competition, Article 5 of the Cartel Act, Article 4 of your competition law. Article 7 of the Cartel Act corresponds to Article 6 of the Turkish competition law, meaning abuse of dominant positions. And we have Article 9 of the Cartel Act, which corresponds to your Article 7, which concerns merger control. With that in mind, what is a price recommendation? Well, a recommendation, first to give a definition, you can see it here. It's a unilateral, legally non-binding statement that is addressed to a recipient and aimed at influencing its behavior. Price recommendations are interesting both for retailers and for producers. Why? Well, if you look on the side of the producer, a producer can basically make a more efficient distribution if it will, efficient distribution by a simple means of targeting a certain desired price level. So it's also very helpful, especially when you are introducing a new product, a new service, to say, okay, as a producer, I think this product is so much worth. On the other hand, you have the retailer who can be very happy about the price recommendation too, especially if you imagine an industry where you would have infinity of products, not infinity, but several different products, and you are the retailer, you don't know exactly at what price you should sell it. Well, the price recommendation can help you here, and also, I mean, you will gain some time because you have an indication, and as such, I mean, price recommendations are good for producers and for retailers. Now we can have a problem. Okay, again, it doesn't. So,
now it's going to.
So, price recommendations are okay. What is not okay is resale price maintenance, as Professor Tanley already mentioned. Resale price maintenance, you can see here, is prohibited by a certain number or described in a certain number of additional documents. The Swiss vertical guidelines, the EU vertical guidelines. I wasn't sure about which communication it was of the Turkish Competition Board, but There was one case I found quite interesting. I will also mention the case Professor Stanley mentioned in his introduction. But one example is the decision of the Turkish Competition Authority of the 30th of June of last year in Mardin, Okla. So basically, what is a resale price maintenance? It's an agreement which directly or indirectly will have the object or effect of restricting the buyer's ability to determine its sale price. So here we see that it's not anymore recommending a price, but it's saying the price should be A, B, or C. So what can we say about that, and how can we distinguish what is price recommendation, which is authorized, and what is resale price maintenance, which is prohibited? Well, price recommendations or maximal price agreements are authorized under certain conditions. Basically, they are authorized as long as you don't have, in addition, certain incentives, certain pressures that would be done by the producer to the retailer to apply a certain price level, or a disincentive, on the other hand, to lower the resale price. So basically, it's okay to recommend the price, but it's not okay to recommend the price and in a disguised way to actually try to influence the price more by, for example, pressuring the retailer by saying, if you don't put the price I want, then I will stop delivering you the product. That would not be okay. And on the other hand, what is prohibited, it's minimum or fixed price agreement. So saying a retailer, I want you to sell my product at least at the price of 10, does not work. The same, it would not work to say, I want you to sell the product at the price of 10, full stop. So this is not okay. And very important link to what I said, the fact that the producer would say, this is a recommended price, and we will see that it was precisely what Pfizer did. Saying it's a recommended price is not enough per se to say that it's actually an allowed price recommendation or maximal price agreement. So the wording of the recommendation does not indicate yet what kind of element it is, whether it is resale price maintenance or price recommendation. So for having a concerted practice now, that we move from price recommendation to concerted practice, you need 3 conditions. Basically, concerted practice is, one other kind of agreement. You have agreements properly so-called. If you have, if I come and see you and I say, let's fix the price at 10, and you say yes, here we have an agreement so-called, properly so-called. Concerted practice is also another kind of agreement, but in kind of more subtle way. And to have a concerted practice, you need 3 conditions, which we will briefly see. First condition is you need a coordination. So basically, a concerted practice will exist when there is a illegitimate coordination among market participants regarding their future conduct. And when is there such an illegitimate coordination? Well, when the market participants can exploit pieces of information that are not freely accessible under normal market conditions. Normal market conditions being what we would call competition on the merits. So basically, in the case of coordination and in a concerted practice, you will have a conscious exchange of information between the market participants. And basically, the coordination will be made possible because this exchange of information will reduce or eliminate the uncertainty that exists in a competitive market. The idea in a competitive market is the competitors don't know about the practice of each other. And when you have coordination, you have an exchange of information that would not be freely available. And this exchange of information takes away the uncertainty. And so the competitors can have an idea of what the other market participant will do. Very importantly, coordination, which can lead to a concerted practice that is prohibited by competition law, must be distinguished from mere parallel behavior. It's okay for undertakings to behave the same way if they do it in a parallel way, meaning if they use only information that is freely available to anyone. And this is a very important distinction. I mean, if as a competitor, if someone on the market, if as an undertaking, you're using information that is freely available, that's okay. If you start exchanging information with competitors, that's not okay. Second condition, if I come back to the agreement properly so-called, I said we set the price. We don't need to prove more than that. If we prove that this price has been set, that's it. You have an agreement. When we speak about concerted practice, we need coordination, but we also need to prove that the coordination has success. So in the case, so it's necessary in that case to assess whether you have a more or less visible behavior on the market, which means also that what will be decisive here will be the compliance rate with the coordination. Are the market participants following the coordination or not? So this is essential. And third condition, you need a causal link between, on the one hand, the coordination, so condition 1, and on the other hand, the success of the coordination. So if we now come to the case, and here you can see, have you received the slides before the presentation? Yes. So this is described, and I will go immediately to this scheme and describe what was written before. So basically, the case starts with, as you can see, Pfizer AG, which is a daughter company of Pfizer International, which, among other things, distributes Viagra, which you all know certainly, in Switzerland for its mother company. You had, initially in the case, you had several other pharmaceutical companies all selling the same kind of product as Viagra, but only Pfizer brought the case to the Federal Supreme Court, which is why I like to call it the Viagra case, even if Oralist is another name that is commonly used. So Pfizer issued so-called non-binding price recommendations for Viagra. And interestingly, so you see it's a recommended price, let's say 20 francs. And this price recommendation would reach the retailers, both pharmacies and physicians, in a processed form through an electronic database system run by an independent operator, which was not part of the proceeding. We could discuss about that, but that was so. So you have this independent database system called GALDAT, in which Pfizer introduces the recommended price. And by introducing the recommended price, it links the price to the barcode of the product. And what happens then? Well, when a retailer, here a pharmacy, scanned a package of Viagra, the price would automatically appear as long as the retailer had not previously changed it, meaning it was kind of a default price. If the pharmacist did not change anything in his computer, it will take over automatically the price that had been inserted in the database by Pfizer. And the nature of the system was known of the retailers. So the retailers knew, all the pharmacies knew that all the other pharmacies would have, that were using all the same database system, the same platform, which basically is a monopolist, as far as I know, in Switzerland. They would all have the same price. And the base of the case was the decision of the competition authority, quite an old decision, from the 2nd of November 2009. So you can see that here too. I mean, okay, you had kind of a going up and down in the case. I don't have much time to discuss that today, but The case made it a first time to the Federal Supreme Court, came back to the Federal Administrative Court, and then went back up to the Federal Supreme Court, which is why it took so long to have the final decision. And the COMCO, so in 2009, already said that this conduct constituted an unlawful agreement eliminating competition. So what are the steps of the analysis? Well, there are two. The reasoning of the Federal Supreme Court has two main parts. The first part is to ask whether the price recommendation was to be defined as a concerted practice that qualified as an agreement affecting competition within the meaning of Article 4 of the Cartel Act. And if this price recommendation could be qualified, could be defined as a concerted practice, the second question was to ask whether this concerted practice was an unlawful agreement affecting competition under Article 5 of the Cartel Act, which I mentioned before. So basically, whether what the undertaking Pfizer called it's a recommended price was in reality a disguised fixed price. First step, is the price recommendation an agreement affecting competition? And here I bring a new element, and you can see this element, it's Article 4.1 of the Cartel Act, which gives a definition of the agreement. And basically, if you want to know whether an agreement is unlawful or not, under Article 5 of the Cartel Act, you are Article 4 in the Turkish Competition Act, you first have to define whether you have an agreement or not. So an agreement affecting competition is any binding or non-binding agreement and concerted practice which has a restraint of competition as their object or effect. In the case at hand, Federal Supreme Court first said there is no agreement properly so-called. There is no, oh, let's fix the price at 10. Oh, yeah, let's do that. And then it asked itself, is there a concerted practice? And first condition, as we saw, was the coordination. So what did the Federal Supreme Court say about that? Well, that Pfizer knowingly and willingly communicated the prices for Viagra to the retailers through the electronic database system. And basically this communication enabled the retailers to become aware of the price recommendation. And what Pfizer knew, knowing how the system was constructed, was also that the retailers, if they wanted to change the price, would need an additional effort to deviate from the recommended price. Basically, the pharmacy or the physician would have to go in the computer and say, I don't want to sell the Viagra 20, I want to sell it 15. So an additional effort. And for the retailers, on the other hand, well, basically, they could assume that the recommended price, the price that would appear on the computer when they scan the product, was kind of an optimal retail price. And they also knew that each of the retailer would have access to the same information. So the pharmacy next door knew that its competitor that was located 2 blocks away would have the same price recommendation as him. So basically what the court said about that is that the retailers at least tacitly agreed with Pfizer's price recommendation as a result of its communication through the database system. And because they at least tacitly agreed with that, the Federal Supreme Court recognized that there was coordination. And this coordination had as its result a reduction or elimination at the downstream level, so at the level of the retailers, of the uncertainty. There was no uncertainty anymore about the price of Viagra, about the reaction of other market participants. And there was a very interesting obiter dictum, so like a en passant thing, you know, like, okay, we have ruled on the case, but let's say something else on a case that would be similar. Because one of the lines of defense of Pfizer was to say, oh, actually, we put the recommended price because the retailers asked us for that. So it was not because we wanted to do that, but because we were asked for. And here the Federal Supreme Court said, well, if this is true, if you accepted to put if you decided to put a recommended price because you were asked for, well, maybe actually we should have qualified this as an agreement properly so called, because in that case you would have answered positively to a request to set a price. So that was more like, actually, if it's really so, then it's worse than we thought. But it was not needed because actually the Federal Supreme Court said, yes, coordination there is. Success of the coordination then. Well, as I said before, it's not sufficient if we have a case of concerted practice. To have coordination, you need the success. So the coordination must materialize in a certain market behavior. And here, basically, you have the degree of compliance with the coordination, so the price recommendation. So the question is, how many retailers among the ones who sell Viagra apply the price recommendation? And these retailers who apply the price recommendation are party to the concerted practice. So the decisive element here is whether or not the price of Viagra deviates from Pfizer's price recommendation. Well, and here the Federal Supreme Court basically said that a concerted practice exists when at least 50% of the retailers, so of the points of sale, comply with the price recommendation. So as we see here at the lower level, we have 1 out of 5 retailers that would not comply. Here we have the price at which they would sell it, meaning we have more than 50% of the retailers that comply, meaning we do have a price recommendation. And second degree of analysis, a retailer is deemed on its side to comply with the price recommendation when it provides a selective discount in fewer than 50% of instances, meaning that a retailer is deemed, on the other hand, to follow an independent pricing policy, so not to follow the price recommendation, when it charges a price that is different from the price recommendation in more than 50% of its sales. Here too we see, if we take one retailer, we look at how many sales it does. Here, out of 5 sales, it would do 1 not at the recommended price, meaning that in that case, this retailer would be deemed to follow the recommended price, and he would be one of the 4 here that would be deemed to follow the recommended price. Yes, of course.
So are those principles valid for all cases, or these principles are only applied to this particular case?
I will come back to it a little bit later, but I would say it's needed to have a special element. And here the special element would be the platform.
Okay.
For me, it's true that saying...
At least these principles are promulgated in this decision. That's
exactly, yes, yes. But linked with the special facts that are to be said, there is a price that is communicated through a platform. I think this is very important because you couldn't say just because a price recommendation is followed that there is actually a concerted practice, because that would take away every possibility to have a price recommendation.
Yes.
So it's a...
If it's a successful recommendation, you follow it. And
exactly.
Typically you follow it.
Exactly. But here you have this supplementary additional element, which I will come back to, but which we already saw, which is the platform, actually. And what do we see here is that the price recommendation was followed by nearly 90% of the pharmacies and more than 80% of the physicians. And then third condition of the concerted practice, the causal link between the coordination and the success of the coordination. And here several elements were taken into account to say that, yes, the causal link existed. First, the direct proof. The Federal Supreme Court said, well, the coordination lasted for years, and Viagra's price was set according to the coordination for a long time. So direct proof is done. And we can add to that two legal presumptions, which confirmed here the direct proof. The first legal presumption is the so-called rebuttable Annick presumption, according to which the exchanged information, so the coordination, will be taken into account by the undertaking when it determines its market conduct. So basically, you have this direct link between conditions 2 and 3. And second legal presumption, which was used by the Federal Supreme Court, here it was to say that, well, an equivalent behavior regarding prices is part of an evidence that concerted practice is working, because the behavior materializes in competition that does not correspond to the competitive price. And here, basically what the Federal Supreme Court said is that these compliance rates did not, in the present case, according to the Federal Supreme Court, correspond to normal market conditions. Why? Well, basically because all retailers did not have the same cost structure. You had small pharmacies, you had large pharmacies, you had pharmacies in the city, on the countryside, you had physicians. I mean, there are not the same cost structures. And basically, the retailers were not able to observe the price of their competitors. So we are not in a gas station case where you could take the car. I mean, if you own a gas station, take the car, drive 2 kilometers and see the price. It's not this case here. You're not going to the next pharmacy, ask for the Pfizer price. So because of that, the Federal Supreme Court came to the conclusion that only coordination could explain this conduct that was the same. And in conclusion, the Federal Supreme Court said that the price recommendation made competition impossible or more difficult, and that it pursued the goal of eliminating competition. And so, for this reason, it was qualified as an agreement affecting competition by object. So first part of the analysis, we have now an agreement, a price recommendation that is requalified as agreement affecting competition by object. Second part of the analysis, is this agreement an unlawful agreement? Well, what is an unlawful agreement affecting competition? According to Article 5, Paragraph 1 of the Cartel Act, it's an agreement that restricts competition in a specific market, and or it's an agreement that eliminates effective competition. And regarding verticals, we have a special provision which says that the elimination of effective competition is presumed. It's the elimination, we are here. In the case of verticals, this elimination of effective competition is presumed in case of agreements that regard fixed or minimum resale price. So we come back to what we saw at the beginning. What is prohibited with regard to resale price maintenance? Fixed or minimum resale price. Well, what was the situation in the case at hand? What the Federal Supreme Court said was basically that the price recommendation on Viagra which was in reality actually a concerted practice constituting an agreement affecting competition by object. This is what we saw already. This price recommendation was qualified as a concerted practice. And this concerted practice was followed, when we check now the number of units sold, by 70% in the case of physicians and 60% of pharmacies. So 60% or over 60% of Viagra boxes that were sold in pharmacies were sold to the recommended price, and over 70% of the boxes were sold at the recommended price by physicians. And this non-binding price recommendation for Viagra was, for this reason, in reality, a fixed price agreement and not a price recommendation or a maximal price agreement, which was unlawful. So basically, if I wanted to go back to all the schemes we saw, we have, if we start at the beginning, pharmacies, for example, that sell over 60% of Viagra to the recommended price, and one pharmacy is deemed to follow the recommended price when it sells more than 50% of the boxes at the recommended price. And if we take that, we saw that, I think it was over or close to 90% of the pharmacies that were selling the Viagra at the recommended price. And we also saw that there would be a concerted practice if over 50% of the pharmacies were selling this box at the recommended price, and we saw that here we had largely over that number. So conclusion on the case, basically a non-binding price recommendation may qualify as a concerted practice, and even more as a fixed price, that constitutes an unlawful agreement affecting competition under certain conditions. Here we had Pfizer's price recommendations, which was communicated through a platform, and basically where no further action was needed on the side of the retailer to have the recommended price that would actually be used by the retailer when they would sell the medicine. And importantly, the Federal Supreme Court said that this kind of recommended price, again like this, could not be compared with price recommendations that are set out in catalogs, such like, for example, in the car industry. Why? Because if you have a catalog in the car industry, you don't have a repeated communication over a long time through one sales system of the price recommendation. So this is one thing. And on the other hand, what Pfizer did, so using the database system, the platform GALDAT, to put the price, it enabled the distributors, so the pharmacies and the physicians, on the downstream level of the market, to know also which price recommendation would be received by their competitor. So basically, the uncertainty on the downstream level of the market would disappear.
Can I ask a question?
Yes.
So, if I understand correctly, so they all receive the same price, right?
Mm-hmm.
These are recommended price, but they are able to change the price as well manually.
They could, yes.
If one of the, for example, physician or pharmacist changed the price, would the others able to see that change as well? I don't think so.
I don't know, but I don't think so. Logically, I don't think so that it would be communicated to the database.
So then, the assumption that this system somehow changed the normal market conditions and they know each other's price doesn't seem to be correct to me. I mean, this proposition doesn't seem to be correct, because if I cannot monitor that, perhaps you change the price, right? So I won't be able to see that. And maybe 30% of pharmacists change the price. So then there's this element of uncertainty here, and I don't know. It's I'm not totally agreeing with the verdict of the court.
I mean, what the court said, because the court checked and came to the conclusion after having done the market analysis that actually the price had been followed by, if I come back,
yes.
Exactly.
But still there is uncertainty in the market.
I mean, in theory, yes, but at the end, because of the special, because of the special conditions, the conclusion would be actually there is no uncertainty anymore. Even if you could change, you will not be inclined to change it. That was more this idea.
Perhaps the audience don't know either. So in Turkey, generally the price of the drugs are fixed, and fixed by the government. I don't think Viagra prices are in that set of
Exactly. We have kind of the same, yeah.
There is a competition. Actually, if I ask no one, the price of it, there, no one knows. It's a drug everyone knows, but no one buys. So,
exactly.
That's another thing. But the issue is that, I mean, do the prices of these drugs actually vary in different pharmacies? I mean, is there a competition in the prices in your system? Because I don't think that we have it in Germany.
We have it. We don't actually. We have. I mean, there is always some kind of competition, as far as I would know, for all kind of medicines, but especially for these hors list medicines. So here, because these ones cannot be bought. Basically, they are not reimbursed if you get a prescription. And for this reason, here you have competition on the price, which was also a specificity of the case, and which is why the case is called hors list medicine or hors list Medikamente in Switzerland. So here you have competition on this, exactly.
But in order for there to be competition, actually the buyers should talk about the price as well, right? I mean, there should be a demand to negotiate the price for this kind of. Do you think that this will happen with this particular?
And that's exactly what the federal, the Federal Administrative Court said in the first case. And so if you give me the opportunity to speak about that. The first time, as I said, the case went, decided by the competition authority, went up to the Federal Administrative Court, and then to the Supreme Court, and then back to the Administrative Court, and then back to the Supreme Court. Well, first time it came to the Federal Administrative Court, what the Federal Administrative Court said was, basically, there is no market for Viagra. And why is there no market? Because men would be ashamed to go buy Viagra. So because they are ashamed, and really, the Federal Administrative Court decision speaks about the shame factor in German. And they said, well, basically, they are so ashamed that it's so difficult already to go to the pharmacy that they would not dare asking for a price reduction. So there would be no market. And on that, the Federal Supreme Court at the first time said, no, come on, stop it. There is a market, there is a product, there is an economy. So the fact that people would be ashamed to buy the product or not doesn't change anything about that. So please, Federal Administrative Court, decide again. And it went down again, and then we had this decision. So, yeah. Yes, of course.
Is there any analysis, decision of the court or maybe of the authority? Did authority compare with other pharmacies, whether the pharmacies follow the recommended price?
Yeah.
Is there difference? For other products, there may not be any recommended price used by electronic system, but again, the pharmacies may comply with the recommended prices. This electronic distribution, this criteria is really important. Does it make difference?
I think it makes a real difference. I don't know whether, if I come back to this, I don't know whether, I don't think so actually, that comparisons were made with other medicine products. I think they just limited the comparison to Viagra, but I'm not sure about that. And as I said, the pricing of medicine products in Switzerland is something I don't, it's quite complicated. I don't get it totally, to be honest, because we have the medicines that are sold and that are reimbursed where you have kind of a system of pricing that is negotiated between insurances, the state is also implied, and also pharmaceutical companies. And then you have the other ones, like this one. And I'm not aware that they would have done a comparison with other medicine products. Yes? Yes? Oops. So, what the court also said was that basically, under these circumstances, you could use this presumption that I already discussed, that basically the conduct of both the issuer and the respondent to the price recommendation were important. And, I'm back here. The decisive element here was the conduct of both the issuer and the respondent to the price recommendation. So basically, in the case at hand, Pfizer accepted, according to the Federal Supreme Court, that a concerted practice would result from the way retailers would use the price recommendation. So uncertainty to of the competition relationship at least partly disappeared, and competition conditions deviated from competition on the merits. What was seen in the market could not correspond to what would have happened if you had had competition on the merits. So why? Because you had this price recommendation that was permanently provided by the producer to the retailer and through this database, and that was, I think, the decisive element in that case that led also the Federal Supreme Court to this presumption under these circumstances, that basically a concerted practice exists when over 50% of the retailers comply with the price recommendation, and a retailer complies with the price recommendation when over 50% of the products are sold with no discount. So it's really these special circumstances that imply, that are applied here, that imply that you have this presumption of the double 50%. So very quickly, 2 words about compliance, because now we have this case, and this case is interesting because such a case hasn't been decided yet at the European Union level especially. And as you will see, Turkey has been using this case for one of its cases, but not with exactly the same facts. And that's why I think it's, from what I read this afternoon, you can criticize actually the competition authority in that case, because here you had this additional element. But basically, compliance will come at 3 levels: at the level of coordination, at the level of the success of the coordination, and at the level of the causal link between coordination and success. If I, because of the lack of time, if I just go through 1 or 2 of these measures, and the first measure is maybe the intensity of the communication. Well, what we had here in the present case was kind of a communication that took place every day for months, for years, because basically the price could be adapted by Pfizer on a daily basis if it wanted it, and the adaptation would be immediately transmitted to the pharmacies, to the physicians. And so here the question is, as a compliance lawyer, what is too much communication? And maybe what can be said about recommended prices or price recommendations is that communication of the price must be kept to the minimum. And what is the minimum? Well, it will depend on the industry. For example, in the fashion industry, it can make sense to have a price communicated, for example, 4 times a year, every time before the collection. This makes sense according to normal market conditions, according to the competition on the merits. If you start to have price recommendation every week for jeans or for sweaters or for whatsoever, I mean, what is the sense exactly? So it will depend on the industry, but important will be that it must be kept to a minimum. Yes?
If, for example, Pfizer communicated not via barcodes in Galdat system, but via emails, for example, that says, okay, you have to sell this at 20 francs. Then isn't it the same as keeping, okay, if they send such an email 3 times a year, isn't it the same thing as changing the value that is stored within the barcode 3 times a year?
Here we would go, linked to your question, to the last compliance recommendation, meaning knowledge of the price recommendation. Why is it different? I mean, there are two things at least that are different in what you mentioned in the hypothesis. So the hypothesis would be that Pfizer would not communicate the price anymore through the database system, but through email. First difference, there is no automatic transmission of the price in the system of the reseller. So if I take my box of Viagra as a pharmacist and that I scan the barcode, well, if I haven't changed the price will remain the same. It will remain the old price. And the second difference, provided you put everyone in, you don't put everyone in CC, is that other pharmacists, other physicians won't know about your price recommendation. And I think even if it's theoretical, it's a decisive element. And this is the last point of the compliance, actually. It's to say, well, it's okay to make a price recommendation, but it's not okay that everyone, all your resellers would know about the price recommendation. Even if they can imagine, that the price will be the same for everyone, there must remain uncertainty. And in the case at hand, there was no more uncertainty because all the resellers, all the pharmacies, all the physicians knew about the fact that they all had the same price. And that's why they had no incentive to change the price. They had no incentive. That's, I think, a decisive element, also linked to your previous question. And I mean, I could go through the other compliance measures, but I will try to keep the time correct. So in conclusion, there is this pioneering role of the Swiss Competition Authority, and which is why this case is especially interesting. And this assessment could actually, which is aligned, I think, with the case law of the European Union, could also be used by the European Union and has already been used by the Turkish Competition Authority in the op-ed case that Professor Sanle mentioned in his introduction. So basically, what you could ask yourself is whether in such a case, this ANIC presumption that concerned, as you remember, conditions 2 and 3 of the concerted practice. So actually that if you have consultation, if you have coordination, then, and that the coordination is followed, then the presumption is that there is a causal effect between the two. You could even ask yourself whether in a case where, just as here, the price is transmitted to the market participants through a platform, well, you could ask yourself whether the presumption should not actually go between conditions 1 and 2. So meaning, if you have coordination, if coordination is proved when the price has been transmitted to the platform, actually it's not even necessary anymore to prove that there is a market effect, because this is something, it's a rebuttable presumption, but this is something you can assume. So this is maybe the first thing you can ask yourself. And the other thing for lawyers, for compliance lawyers in undertakings, it's very important to understand that basically an undertaking that provides information regarding its prices, that makes recommended practices, must be particularly vigilant, and that account must be taken of the effect on the market due to the reduced uncertainty. So basically, it's a very important role of compliance, of lawyers and of in-house counsels following the Federal Supreme Court judgment. And what must be understood here is that a certain degree of compliance under certain circumstances, such as the ones we saw here, like the price is transmitted through the platform, can be sufficient to have an agreement that is considered to restrict competition and that is unlawful. So, yeah, I think this is a case that brings food for thought. And once again, I'm very thankful for you for attending my presentation tonight, and I'm looking forward to your questions. Thank you.
Thank you very much, Professor Canapa. And now, do you have questions? And our guests in the Zoom platform? Again, okay.
So you mentioned that this is not the case in Turkey, but you said that physicians can also sell certain drugs in Switzerland. Is that correct?
Yes, exactly,
okay.
yes.
So my question was, since this is considered a concerted practice between the resellers and the physicians,
the concerted practice was actually, it's a vertical one.
Oh.
So the concerted practice, oh sorry if I wasn't clear about that, the concerted practice is between Pfizer, so the producer, and the resellers. And the resellers were both physicians and pharmacies. So there was no horizontal
I was going to ask whether or not the resellers were also fined.
No, they weren't. They weren't. This is also, I mean, two actors were not fined. But actually, as vertical case, they could have also fined the resellers. But two actors were not fined. And no one understands really why. Maybe because it was easier to, it's easier to take Pfizer, you take the medicine producers, and you say this is prohibited, and we leave the pharmacies on the side, and we say, okay, you didn't know, but now you know. So pharmacies and physicians weren't fined, and so wasn't the platform, which is also interesting because the platform was here in the middle, and it knew exactly what it was doing, but it wasn't fined either. So there's no answer to that question.
So apparently there were other medicines that is marketed through this platform, right? There were other medicines as well. So I'm sure that Competition Authority of Switzerland have checked the position or pricing scheme of other medicines. I mean, what about the other medicine? Is it, so it should be this case, looking at the facts of the case. So only the Pfizer medicine prices are followed by the physicians and pharmacists, not the others.
You had, I mean, the original case, you had all a series of medicines that have the same use as Viagra. I'm trying to, I have the name in German, the Potenzmittel, but I forgot the English name, so yeah, I won't describe what they are used for. But so you had a series of producers that were fined, but all the other producers decided they were fine with the sentence, and they didn't bring the case to court. But you had others, I think Bayer was fined, and but only Pfizer brought the case to the Federal Supreme Court.
Okay, all right.
So what's really interesting is to me, you said that this 20 franc price is like a default price. When they enter the system, it's automatically just there. So if the system was designed as like, says this is just a recommended price, it's not binding, and force the retailers to enter their own price, would the decision change? Would anything change in that
In my opinion, yes. In my opinion, yes, because then you would have, I mean, at least, let's say it's, we could put different hypotheses and say yes or no, but a major change would be that in this circumstance, you still have more uncertainty. You have a recommended price, but you don't know what, if you're a pharmacy, you don't know what your neighbor pharmacy will do. Will it take over the price, 20, or will it put less, or will it put more? I don't know. So here you put back some uncertainty. And here I would add one more element. If the price, let's say, changes every week and that the pharmacies are not notified every week that there is a price change, or notified every week about the fact that you have the same price again and again and again, here again you would have more elements that would tend to say, well, it's a price recommendation, but is it really one, or is it more, a try to have a fixed price? But let's say Pfizer would put the price in the database, let's say twice a year, and it's the pharmacies are informed there is a new price, but you do whatever you want with it. I think it's a major change with the current facts, or with the facts of this case. Okay, so if Pfizer could prove that the use of resale price-defined barcodes has been offered as optional to retailers, which was the case in a sense, and provide some materials proof showing that the retailers have accepted to use the barcodes with their own choice, what would be the decision? I mean, if I understand, it's similar to the question of your colleague, meaning if Pfizer had only put a price and said, now you do whatever you want with it, but it doesn't go automatically in your system, then we change totally, I think, the case, because here we have uncertainty. And here we are back to, in a digital world, but we are back, in a sense, to competition on the merits and on a producer that proposes a price. Maybe one element that I could have added is one big difference between this case and a brick and mortar case, or the case where you would transmit the price with emails, is that here all the distributors knew about the price. And this is maybe something that is interesting linked to your question, because pharmacies would still know about the price that others have as a recommendation. And here there is some uncertainty. And I would say, but it's only, I'm the only one engaged here by saying that as long as it's simply saying this is the price without any additional element, it should be okay, even if the others kind of know. But if there is any other element that goes further than that, then it's problematic. Then it's problematic. It's all about the uncertainty or certainty you have about what the others would know.
My question might be off topic. So there are some algorithms that are monitoring the competitors' price and make price corrections according to that.
Wait, what is making price corrections? I'm sorry.
Algorithms.
Yes,
AI.
okay.
Kind of algorithms that are used by resellers, especially in e-commerce. Do you think the use of algorithms constitutes an agreement or concerted action? Because algorithms start to work in parallel each other over time. And does the parallelism of the algorithm count as the parallelism of the enterprise that is using the algorithm?
So it's here about algorithmic pricing, basically your question. We could go further and speak about artificial intelligence that is setting the price. There have been some studies which have been done, and I must say I tend to agree with them. It's, if we go back to the non-digital world, what would be problematic? It's two people who would agree immediately or through a concerted practice to set a price. If the algorithm is programmed by a human in order to adjust the price and that it understands that, well, the higher we go, the better it is, the prisoner's dilemma, if it understands that, for me, clearly this is something that has to be prohibited by competition law. So we are here in price setting. And the same with artificial intelligence. If you program something saying you will be able to set the price by your own and that the artificial intelligence starts understanding that, well, there's no reason, because it's not a human but a machine that sets the price, that it should not be under the scope of application of antitrust law and competition law anymore. So, answer to your question, yes, I think this is a problematic algorithmic use. And predecessor, which was quoted actually by the Federal Supreme Court in the, a previous case that was quoted by the Federal Supreme Court, is the Eturas case of the European, of the Court of Justice of the European Union, Eturas, so E-T-U-R-A-S, which was not exactly algorithmic pricing and which was decided in kind of a weird way. But basically what the court said here, and what can be taken over, is that if you have, just as here, a price that is recommended and that everything, in order to prove that you are not following the price, you have to clearly say, I'm not following it. And if you don't do that, you are, as an undertaking, we will go from the presumption that you are following the price and that that the agreement exists. Okay?
Thank you. Soru var mı Zoom'dan? Do we have any questions from the Zoom platform? I think. Okay. One final thing. What happened after this case? So they have apparently put some efforts in terms of compliance and they change their practices. Do you have any idea what happened to the prices of these products? Will there be competition again? The prices varied through these?
I don't know. Sorry, this is something
case.
interesting.
Okay, maybe Muzaffer is signaling me that I should stop. All right. Thank you very much again for your presentation.
Thank you.